and that's the property. That's the
new transfer road.
Public adjuster.
When he bought it, I just looked it up.
Could everybody please mute themselves? If you're not talking, please mute yourself. Thank you.
Thank you. Okay, House Bill 36, Public Adjusters, Protection After Loss or Damage to Property. The bill as it came in has extended rescission period for a public adjustment contract for those who are 65 or older. I would qualify, making it a week, 7 days rather than 3 business days, which is the current law. The bill also, as it came in, takes the qualification that essentially insurance fraud by contractors caused by damage to where you're dealing with damages to a private residence. This is the "we'll buy a roof for you" provision. Currently is limited to weather-related concerns, and the amendment takes that away. However, the other portion of the bill that our committee chair objected to was a prohibition on solicitation or attempting solicitation within 24 hours after a loss or damage and between 8 p.m. and 5 a.m. Essentially storm chasers, but for up to 24 hours afterwards. The Senate has moved the bill in a somewhat different posture, but this is the provision that the committee chair violently objected to. So the amendment that we have here is to strike the 24-hour provision, but to retain the extended public adjustment contract rescission period for 7 days for those who are 65 or older, and then also to take out the weather-related qualification for provisions against insurance fraud, paying for the deductible with the return. Amendment then. Discussion. Anyone want to move the amendment?
Move the amendment.
Thank you. Is there a second? Is there a second, please?
Second.
Sorry, I was on mute.
I was on mute. I'm sorry.
So we're moving the amendments first.
Mhm.
Are there any discussion on the amendments? Okay. Seeing none, all those in favor signify by saying aye.
Aye.
Any opposed?
Somebody got their hand up.
Any abstentions?
That's Jamie Sexton from MIA.
Jamie, did you have a question?
I did. I understand that we're talking about the chair's amendments. I just wanted to verify that we would have the opportunity to discuss the amendment submitted by the MIA on the departmental.
Which essentially puts it into the posture of the Senate bill, as I recall. I'm sorry, I don't have the text right here. So, you want to describe it, Jamie?
Yeah, absolutely. I'm actually going to turn that over to Joe Smith on our team, who's the SME on this matter.
Good evening. How is everyone tonight?
Good. Go ahead, Joe.
Just to discuss the amendments, we had proposed amendments that would remove the solicitation within 24 hours after a loss, and we would keep in no solicitation contemporaneous with a loss and no solicitations between 8 p.m. and 8 a.m. The consumers, when they're facing a loss like that, are very vulnerable in that moment of the loss occurring, such as a house fire, and an individual shows up and solicits their services. That individual may not know who this person is, or may not have the wherewithal to read the contracts, identify who the person is, and understand that when they hire a public adjuster, without giving the opportunity to thoroughly review the contract, that the proceeds that are paid by the insurance company are then diminished because a fee has to be paid to the public adjuster. So we receive complaints regularly that an individual public adjuster would show up contemporaneous with the loss, and the individual believes at that moment that the public adjuster is actually with their very own insurance company. I just received a call last week from a consumer who felt vulnerable, and during a solicitation that occurred when the fire was occurring at the house, and entered into a public adjuster's contract. And there's no way that we can protect them without the important legislation that would protect the consumers. And as far as home improvement contractors that may show up, they are covered by the Door-to-Door Salesperson Act if they solicit business during a loss or certain times. Then the Door-to-Door Salesperson Act would kick in, which extends the period of time in which a person can decline or cancel the contract.
Okay. The only thing that I would say is that you have these amendments already in the Senate side, right?
Yes, sir.
All right. I mean, what I would suggest at this point is we confer when the Senate bill comes over. So like we pass the bill the way it is now, the way everybody's, I guess with the exception of you guys, agreed to it. And then when the Senate bill comes over, then we can, and when the House bill comes back, we can confer that way when the House bill comes back from the Senate. Otherwise, we're going to lose some time. Is that right, Bob?
That's correct.
Not that we're opposed to any of those things.
And Bob, I think that you should have that language, if I'm not mistaken. I think we submitted that just before the hearing. Wonderful. Just want to make sure you have everything you need. And just one other point I do just want to make on this is the 24-hour after a loss issue. We had heard there were some constitutionality concerns around that, which is why we sought to address that via an amendment.
Yep.
We actually think that the bill as amended comes out actually a stronger consumer protection to begin with. So I know that concern was raised with a few members. So just wanted to address that, we heard that and we tried to address it accordingly.
Thank you. All right. Did we vote on the amendments?
Yes.
Did. So now on the bill as amended, is there, can anybody move the bill as amended?
Move the bill as a second.
Second, all right. Is there any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Okay, the bill is moved as amended. Let's go on to AIDS House Bill 252, Bob, is that right?
Correct. Let me see if I can, I will have to bring up a different reprint on this one. This is one of the rather significant bills that come in periodically on holding company systems. This is an NAIC accreditation bill, so that of course means that we kind of have to do it. The amendment that is propounded by the MIA, which I slightly tweaked, and I hope I didn't do too badly with, adjusts the non-disclosure language, the protection of confidential information by the commissioner when she's reviewing these documents, materials, and other information, and provides that essentially certain disclosures that may be misleading are prohibited, and also gives the opportunity for an insurer or insurance holding company that feels that disclosure has harmed it in some way has the opportunity to make a statement to correct the record. So that's essentially a long explanation of a convoluted amendment to a much longer bill. So there's the amendment. I believe Ms. Sexton has someone online in case there are any questions over these things.
Was this bill cross-file?
No, that's why we had it this way. Most of this was filed too late to be cross-filed in the Senate. It wasn't timely for pre-file, and the Senate requires departmentals to be pre-filed.
All right, any questions? Delegate Amprey, did you have a question?
Oh no, I was
Move the bill.
Okay.
sorry.
Amendment.
I was gonna say, you need to move amendments, don't you?
Yes.
Mhm.
the amendment first.
Oh, I'm
Mr. Chairman, I
sorry,
move the amendment.
Second.
Okay, and we have a first and a second. Is there any conversation on the amendments?
No.
All those in favor signify by saying aye.
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 Any opposed?
No.
Move the
Any
bills amended.
abstentions? Great.
I'm not abstaining to that amendment. I'm sorry. I didn't have any, I voted for the amendment.
I got you. It all went quick.
Mr. Chair, I move the bill as amended.
Thank you.
Second.
So, okay. On the bill as amended, all those in favor signify by saying aye.
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 Any opposed? Any abstentions? Bill passes. Okay,
Okay.
last bill of the evening is HB 647.
Okay, if I can get to, this is being, Zoom is being a little strange for me, sorry. But, okay, new share. So the House bill
It's the pet insurance.
is the pet insurance bill, and I'm trying to, okay, come on. This is just being strange. I apologize. Okay. I apologize, folks. I'm just desperately trying to find this.
Take your time. Thank you.
Okay. Essentially, what's happening here? We have the pet insurance bill that Delegate Guyton brought in. It's from an NAIC model because currently the pet insurance industry is relatively unregulated. This is an NAIC model that they've used. The concerns that were brought in the amendment were to strike as potentially duplicative. Here we go. So come on, here we go. iPhone, iPad. Let me see, is this it? Yes, here we go. Pet insurance regulation. So this provides a uniform framework for regulating pet insurance in the state rather than it just being an otherwise unremarkable regulation of property. The amendments that were brought in by Delegate Guyton make a policy choice regarding marketing of pet insurance versus wellness programs. The bill as it came in would prohibit a pet insurer or a pet insurance producer from marketing a wellness program during the sale, solicitation, or negotiation of a pet insurance policy. And the amendment strikes that and simply provides that the insurance producer may not market a wellness program as a pet insurance policy. There are certain criteria under which a wellness program, if it provides certain things, could be considered pet insurance. But this would, as I said, the bill as it came in wouldn't allow them to market together with the amendment that she's propounded. One thing that it would do, the first policy point, is it would strike that prohibition on dual marketing.
So it basically puts it back in the original intended posture that it came in.
Well, what I'm saying, what I'm sharing on the screen is actually Delegate Guyton's amendment. You and I had discussed, and I believe you discussed with Delegate Guyton, that you would want to not take this portion of the amendment.
That's correct. And just my conversations with the bill sponsor, just so everybody's aware, is the idea that what we were concerned with is the idea that somebody is signing up for pet insurance for the very first time, since it's been virtually unregulated. And then at the same time, they're selling pet insurance. There's also the sale of wellness, like a wellness program. And the thought being that we were concerned that somebody might get confused, order the wellness program, then a few months later or a year later, after paying into this wellness program, find themselves in a situation where they actually need pet insurance, thinking that they had pet insurance because they thought they bought pet insurance, but actually ended up in some kind of wellness program. And then they're sitting there with a $2,000 or $3,000 or $4,000 or $5,000 pet insurance bill that they're not going to be reimbursed for or paid out. So the idea was to just make it like delineate those things so that there's no confusion when somebody's making that purchase.
So is that the amendment?
That's an amendment to the amendment, actually.
The amendment. So
yeah.
how do you need to move this? You need to move the bills amended and then take the second amendment in a second?
Well, you would modify the amendment by striking this provision that by essentially restoring the bill to its original posture on this page, and I can handle the details.
Mr. Chairman, I move the amendment as being described by council.
Thank you.
Okay. The remainder of
Second.
the
We need-
amendment, yeah,
We
the
still need a
remain,
second.
second,
okay.
Thank you.
The,
So
okay,
discussion.
the remain, if I can say, the remainder of the sponsor's amendment strikes particular penalties and suspensions of licensing that the commissioner could impose, as well as authorization for the commissioner to adopt regulations, most of which is actually, I suspect, redundant of the existing authority of the commissioner under the insurance article. Mr. Van Dorsey from MIA is here, and I believe may have some comments on this.
Mr. Dorsey, please go ahead.
He's muted.
You're muted. You're still muted.
He's having my kind of luck with the computer.
there
My,
you go.
my apologies there. Can you hear me?
Yes,
Yes, sir.
Yes.
Okay, yes, thank you. With regard to the First Amendment, I do want to note that the MIA does support the amendment as written. And the reason for that, it is true. Currently, pet insurance is regulated by the MIA. It's a form of inland marine property and casualty insurance. The bill does set up guardrails around how pet insurance is sold, and we think it's very much a good thing. With regard to this particular amendment, it's important to understand, I think, how pet insurance is sold, and because it's often sold, at the veterinarians, over the counter, and so, when and because the veterinarian will have an insurance producer's license also. And so they can sell the pet insurance. And then the question then can become, do you want a wellness program with that? And if they can't do that, then, essentially the office has to say, I can't sell you a wellness program, but you have to come in the door and come back, and then I can sell you a wellness program. And so we think as a practical matter, that doesn't really jibe with how the marketplace works at this time. It's certainly incumbent on the producer to make sure that the consumer understands the difference between the insurance policy and a wellness program. And also it's also important to point out, a wellness program can also be part of an insurance contract. So, that the statute actually allows for that. So there are actually three different things you can do. You can have just the insurance policy, you can sell them both, or you could have it in the policy. So we think that the best thing to do is to really allow for, greater opportunities for the consumer to choose what they want. And with regard to the Second Amendment, Bob is right. The order and penalty provisions of the bill really are duplicative of existing law, which already applies to property casualty insurers and producers who are subject to this. I see there's a question. I'll shut up.
Yeah. Delegate Adams.
So Bob, do I need to withdraw my amendment as it was being described and then have the committee consider their testimony?
Theoretically, if we all agree with Mr. Dorsey, I'm not sure Mr. Dorsey's made a strong enough case for me, but go ahead.
I would say that you can decide, you can talk about which way you want to go, and based on that, then Delegate Adams, you could withdraw the motion.
Why don't we do this for the sake of the conversation, Mr. Chairman? I'm going to withdraw the amendment. I thought this was sort of sorted out, but why don't I withdraw it and at least let's talk about what it is that MIA is discussing, because I hear what they're saying.
Yeah, so I'll just say, Mr. Dorsey, I appreciate what you're saying. I will say that having multiple pets, and sometimes emotions become involved. I respect your opinion. I don't want to come across as I don't respect your opinion. I respect your opinion. I just think that the people can be in a very vulnerable time, and they can buy things that they don't actually understand what they're buying. And I still have some significant concern that we could be putting people in a position and maybe where they don't understand what they're doing. So that's why, I mean, that's where I don't know what the rest of the subcommittee, what their thoughts are on this, but that's where I am.
Well, Mr. Chairman, and not to take over the conversation, but I think what MIA is saying is that this is more about how the market approaches the sale of any of these sort of plans, and that they're not, it's like buying a car in so much as you're presented with opportunities to buy extended insurance, maybe things that relate to protection of your paint, et cetera. Not everything that they're offering you is insurance. It's a quote unquote add-on sale. Now, I would agree with you that pets are a personal extension of a family, if not part of the family. And buying this insurance probably feels a lot more like buying health insurance. In other words, you want to protect the family from, I don't know that it's day-to-day wellness issues, but you certainly as a pet owner want to protect against catastrophic and or some major medical expenses. But at the same time, after you've made that delineation between the insurance that I'm assuming pays for the major medical, that one would also be presenting you with okay, this is how much it costs every year to get the shots, to do the wellness check. And instead of having to pay each time you go to the vet, maybe it's a monthly expense, or maybe it's a program, and they throw it all into one sort of payment. So I do think that they probably, from a marketing standpoint, view these things as collectively part of a decision that a pet owner is going to go through. So I actually accept what MIA is saying here, and which is the reason why I would withdraw the amendment. Now, if there's votes to take the amendment pulling out the wellness program, then just I'm going to vote against that and just let the will of the committee move forward. So the point is I'm going to withdraw the amendment just because I think that's the right thing for me to do, knowing that there's some MIA testimony on the front. And then why don't you just take it from there and
yeah, that's fine. I don't know if anybody,
Is this, Mr. Chair?
Yes.
I'm trying to get a clear understanding. Is this either or? Either you can have just the pet insurance, or you can have the pet insurance and the wellness, or just the pet insurance? Are you saying that we have a choice?
What we're saying is so there's two choices right now, Delegate Turner. One of them is that when someone is sold pet insurance, they can be sold pet insurance, they can be sold a wellness program, they can be sold other things at the same time.
Okay.
And there are some folks that think that when you're selling the pet insurance, if you were to sell a wellness program at the same time, that might confuse the purchaser, or that might confuse the owner, and they may end up purchasing the wellness program thinking that they purchased the insurance program. And then that could get them into, a state of bother 4 months or 6 months or a year down the line when they actually need the pet insurance and they find out that they didn't. So there's two schools of thought here. One is that we should not allow people to be marketed too heavily when they're making this kind of a potentially emotional decision. And then there's the other school of thought, which is coming from MIA, Mr. Dorsey, and Delegate Adams, which is just let them sell whatever, and then you buy whatever, and it's on you because you're there at that time. So
I'm with Adam.
okay. Delegate Ampry, do you have anything you'd like to add?
Nope.
Mr. Chairman, I'll move the amendments as better described by MIA and without the second amendment that would have pulled out the wellness program.
So the amendment from Delegate Guyton as presented.
Yes.
Yep. Okay.
All right,
Second,
all right. All those in favor signify by saying aye.
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 Any opposed? Okay, it carries.
You gonna move the bills amended? I move the bills amended.
Thank you, Delegate
Second.
Adams. Okay, on the bill as amended, is there any discussion?
Wolf.
All right, all those in favor signify by saying aye.
Aye.
All those opposed? Any abstentions? Motion carries, bill carries.
One question, I'm sorry. Is this a cross file?
Oh, let me look up. Is there a cross file to this?
A quick look at this HB 647.
It doesn't look like there's a cross file.
No, I don't believe so.
Okay, we're good.
Yeah, we do have to, once this comes to the full committee, we also have to get sign off from ENT because it's jointly assigned
Oh,
because of
okay.
the veterinarians being involved. So,
All right,
Okay.
so we are done for the good of the order, right, Bob? We're done?
yes, sir, you taken care of all three bills.
All right, thank you,
Okay.
everyone.
bye-bye.
Thank
All
you.
right.
Okay, have a good dinner.
Yeah, I'll see you.